to everyone. We are from Genevieve and Co. Medical practitioners under the ministry often be called to testify in court as experts in criminal and civil trials. The purpose of this video is to provide with the basic information before stepping into the courtroom to give testimony. Prior to admitting an expert witness or an expert report to an adjudicating body, the adjudicating body shall have to be certified that he has the appropriate expertise and experience. He is familiar with the duties of an expert. There is no actual or potential conflict of interest. An expert is a person who is an expert in matters of science or art. Section 45, 46, and 51 of Evidence Act 1950 deals with the opinion of experts. This can be seen in the case of Genevieve versus public prosecutor, where the test to be applied is to determine whether a person is an expert. First, does the nature of the evidence require special skill? Second, if so, has the witness acquired the necessary skills either by academic qualifications or experience so that he has the adequate knowledge to express an opinion on the matter under the inquiry?
The stage where you will be called to testify is a trial proceedings. In general practice, you have to go through 3 stages, which are examination in chief, cross-examinations, and re-examinations. I have inserted specific sections here for your reference. Before those stages, you need to take an oath. In Malay, we call it angkat sumpah. You may also let the court know your preferred language, like in Malay or in English. In the examination in chief, you have to respond to the question given by the party who call you to attend this court. Let's say you are the victims from defense side. The defense lawyer will then ask the open-ended questions to you. Proceed to cross-examinations. It is the opponent's lawyer turn to ask you some questions. They attempt to cause you to answer the question to your party's disadvantage. But you are merely required to answer yes, no, or state you have no knowledge about it. Lastly, in re-examinations, the party calling the witness will give you an opportunity to explain any matters raised during the cross-examinations.
When you are being called to be an expert witness, you must understand that your role is to assist the court in a matter relating to your specialization. With that, you must restrict your statements to areas that are within your professional competence. If a particular question falls outside your area of expertise, you should either refuse to answer or make it clear that you consider that matter to be outside your competence. Besides, your opinion must be given objectively and without bias because you are obligated to act independently and impartially before the court. In order to provide sufficient understanding to the court, you must be able to state how and why you say so. This is also in accordance with Section 51 of the Evidence Act, which necessitates the experts to support their opinion with reason. If you do not explain how you arrive at your own view, the bare expression of opinion would not carry any weight. In addition, you must always remember to use language and terminology that a person with a non-medical background can understand. It is also encouraged for you to explain the medical abbreviation and unintelligible terms in layman terms in order to avoid any miscommunication that could affect the case. Sometimes, you may also be asked for an opinion based on a document or description given by the court. For instance, the solicitor gives you another witness description of a dead body. According to the law, even if you had not seen the dead body by yourself, you can also give your opinion based on your study and experience. Generally, you will be asked to assess the accuracy of the diagnosis and the overall medical decision-making process. Your opinion in this regard can help the court to understand the complex medical matters in the case.
As an expert witness for a court case, it is important to answer all the questions issued by the parties clearly and precisely. There are a few typical questions that would be asked by the counsel.
There are 2 distinguishable characteristics of questions that would be asked by the counsel. The first would be the questions to establish your skills or expertise. And the second questions will be issued in relation to your knowledge on the circumstances of the case.
An example of what questions would be asked are like this.
What is your qualification?
I have a bachelor's degree in medicine from the International Medical University and have been practicing at Hospital Sultanah Aminah for 11 years.
So can you tell which department are you stationed at the hospital?
I am stationed at the Emergency and Trauma Department.
How many years exactly that you have been stationed at that department?
For 6 years.
Do you have any specialization in the department assigned?
Yes, I specialize in head trauma and breathing impediments.
Have you ever been called to give witness statements as an expert?
Yes.
So what was the witness statement accepted?
Yes, my witness statement was accepted. So, do you know why you are here today?
Yes, to give witness statement upon an alleged murder case.
Referring to Exhibit P3, can you identify that this is the report produced?
Yes.
How can you identify it?
I wrote it and I have issued my signature including the date the report was issued and signed upon the document.
Who did you examine based on this report?
I examined Mr. Hassan bin Minaj, which is the deceased.
And how did you examine him?
I performed an autopsy on him.
So based on your examination, can you identify how the death was caused?
It was actually caused by a blunt object to the head with excessive force causing head trauma.
How can you be sure it was caused by a blunt object?
It is based on the pooling of blood and muscle trauma around the wound, the size and the length of the contusion, which happens when a part of the body is injured, and then the blood from the damaged capillaries leaks out.
Have you ever performed autopsies with similar findings?
Yes.
Thus, can you be sure of what type of blunt object could have caused the injuries as the deceased suffered?
According to my examination and experience, I find that injuries of the same type can be caused by any hard and long object, which is the same as a large stick or pole. This could be a baseball bat or a pipe of some sort. Do you know why you are here today?
Yes, to give my witness statement for an accident case.
So can you tell us who did you examine that is related in this case?
The name of my patient was Jackson Wang, and he was brought into the emergency department due to a motorcycle accident.
Can you also identify the documents that have been put in front of you?
Yes, they are the reports that I have produced on 16th June 2023 relating to the admissions and treatments of Jackson Wang at the hospital.
Right, so how can you identify them?
I have produced these documents. I have also included my signature and date of report and signing on the document.
So can you tell us more about Mr. Jackson's injuries?
Yes, he suffered a right knee dislocation, a broken right index finger, and a fractured right fibula and a right ulna.
And how exactly could these injuries occur?
Well, the injuries actually show that the patient experienced a force of impact, pushing him onto a hard surface where the point of impact mostly resulted on the right side of his body, experiencing the shock and resulting in the injuries.
So as you stated, the patient was brought in for a motor vehicle accident, correct? So were the injuries sustained the result of an accident occurring in the nearest time frame?
Yes. Through my examinations, I found the injuries to be fresh and new and resulting from a recent accident.
Doctor, do you happen to know whether the patient had any other injuries?
The patient did have a medical history from the hospital which showed that he suffered from an accident in 2010, resulting in a broken femur on his left leg. However, from this accident, it showed that the left side of his body experienced minimal impact apart from a few cuts and bruises.
So have you ever examined any similar cases as this before?
Yes.
So you can confirm that the injuries sustained by Mr. Jackson were not from a previous injury and are in fact new and relevant to the prior accident he experienced?
Yes, they were.
On top of that, as a reminder to the responsibility of an expert witness, the duty of an expert witness is to assist the adjudicating body on matters that are within his expertise and maintain neutrality. Thus, an expert witness has a duty to act independently, be honest, trustworthy, objective, and impartial. Next, aside from assisting the adjudicating body, the expert witness also must ensure that any report, written, or evidence is given to the court is accurate and not misleading. This means that the expert witness must take reasonable steps to ensure and to check the accuracy of any information given and to make sure that all relevant information is included before the start of the proceeding. And if by any chances an expert witness wish to change his opinion at any time, such changes should be communicated immediately to the adjudicating body and the other parties that involved in the proceeding. To conclude, this video comprises a simple explanation and procedural part of how an expert witness testify in a court for your future guideline. And if you wish to know more information, contact us through our website, or you may consult further with your respective lawyer. With this, we hope that this video is helpful for those who need as a guideline. And thank you. Have a nice day.